for case management for an attorney.
You mean not?
You know that guy?
Joshua McCauley.
I get breakout room final soon.
He's supposed to.
Joshua McCauley, can you hear me?
Oh, God.
There he is.
He just went in there, Mr. Feigelson.
That's entrapment. That's what that is. That's entrapment.
Okay, let's see. Mr. Goodrich is present. Okay, on the record in the matter of the people of the state of Michigan versus Justin Holland, file number 24-02199. Council appearance.
Good morning, Your Honor. Casey Markarian, appearing against the people, making a motion to practice under Michigan Court Rule number 8.120.
Motion granted.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Holland, who's appearing over Polycom from the Ingham County Jail today.
Okay, today was the date that was scheduled for a probable cause conference. This matter is scheduled for preliminary examination August 29th, 8:30 in the morning in person at the court. Are we continuing to examine?
Your Honor, I would like to address his bond situation at this time. I am personally not going to be here on the 29th. If the court is willing to reinstate his bond following argument, I would be asking that the court adjourn the matter out until a date I could be there. Otherwise, I would rather, if he were to remain in jail, I would prefer to get somebody from my office to cover the hearing because I don't want him to, wait extra weeks for me because I'm out.
Why did he miss court?
Well, Your Honor, the first week for the probable cause conference, he showed up at the building with a cane that was not allowed through security. I don't know if they deemed it some type of weapon. They told him he had to leave the property. He ended up leaving the property. And by the time he got that issue taken care of, he missed the court hearing and didn't appear. He did show up last week as well. Which was the original preliminary exam date. On the way to court, he actually got in an accident on his bike where he ended up breaking his clavicle. He still showed up to court. However, he was taken into custody because of the bench warrant and remanded at that time. As court can see, his arm is currently in a sling from the broken clavicle. So we would ask the court to reinstate his bond at this time. I know he had some phone issues, so I didn't get connected to him, that morning of their first PCC. So I would ask the court to reinstate his bond at this time. And if the court is willing to, we would like I said, like to adjourn the preliminary exam if possible.
Mr. Holland, what's your phone number?
My old phone number is 517-303-9228. I bought a new phone the day before court, so I could it has a new number that I don't have memorized. I have to get my old number ported to my new phone. So my old phone was stolen while I was away. I don't know if that makes sense.
Okay. I'm gonna reinstate his bond. You need to update the court with your phone numbers or your phone number within 24 hours of being released. You've already waived the timeline, I guess, for the exam because you missed your original probable cause conference and exam. So we will reset this.
October 17th at 9.
October 17th at 9 a.m. is the new date for your preliminary exam. You need to appear in person, okay?
Exam. Can I get? Will I be given that in writing? I don't know if I can remember that. October 17th, 8:30 a.m.
How about this? We can't give it to you in writing because you're in Ingham County and your attorney can't even call you, nor can the court call you. So when you come in within the next 24 hours of your release to give us your updated phone number, we'll give you a copy.
Perfect. I apologize.
No problem. Just come in, ask for a copy of your notice to appear, okay? Any additional matters for today's record?
Nothing further from the people. Thank you.
Nothing from the defense, Your Honor. Thank you.
You're all set, Mr. Holland.
Thank you, ma'am.
On the record in the matter of the people of the state of Michigan versus Carl Knox, file number 24-02343. Council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Knox. I'm here in the courtroom. Mr. Knox joins us on Polycom from the AM County Jail.
Today's the date set for probable cause conference, and the matter is scheduled for preliminary examination August 29th at 8:30 in the morning in person at the court. There was a note here that said he needed fingerprints, but that's not. Oh, is that because the system is down?
Yeah. So next week.
Okay, so when he comes in person, he has to get fingerprinted. Are we continuing to examine this?
Yes, Your Honor.
Any matters we should address while on record?
Yes, Your Honor. Mr. Knox has asked that the court hear bond at this time. I'm motion on.
Proceed.
Thank you. Mr. Knox has been in jail since the 9th of this month. According to my math here, it appears he has been in custody 14 days as of today. He is employed. He's trying to get back out. He is the caregiver to his mother, who is very ill. She's in the hospital right now, and she needs somebody to go back to her house to, one, make sure her pets are all right, and take things into account of just making sure everything's secure at the house and taken care of, as well as he would like to be able to go see the hospital as she is very ill. He has holds out of other counties at this time, Jackson and Clinton County. So he would also still like to he needs to take care of those two. A PR bond would allow him to go take care of that and perhaps get out to take care of his mother, or at least her animals, while she is in the hospital. He does show up to court. He does acknowledge he does have a record, but he does show up. And if the court were willing to consider it, I'd even say potentially a tether could help us to make sure that the community is kept safe. I'd ask the court to consider him for a PR bond or reduce the bond at this time. Thank you.
Reduce the bond, it's only 3,010%.
He's been in 14 days, Your Honor, and he has not been able to post it.
Well, that's not a consideration. It's only, you just gotta pay $300. How can I reduce it? This is assault with a deadly or a dangerous weapon in a controlled substance, habitual offender fourth offense notice is how it's charged. It's a really low bond considering that. Did you want to respond to the bond motion?
Your Honor, I will ultimately leave the decision on the bond to the court's discretion. If he is released, we would request a GPS tether upon release, and for the court's reference, the allegations for the assault with a deadly weapon are that an airsoft pistol was used. I haven't been able to determine the caliber of it yet and all that, but just for the court's knowledge.
No, I have his criminal history. Magistrate Moore had it when she issued this bond on the 10th. What is this hold for in the other courts?
One's for a traffic ticket and the other one's for FOC out of Jackson County.
Parliament the bond to 3,000 personal recognizance with GPS tether. What's your home address?
4447 Chadburn Drive.
You need to appear in person next week for your court date, okay?
That's your honor.
Your other bond conditions will continue, including the no contact order for the alleged victim. Any additional matters for the record?
If I may, Your Honor, I just want to put on the record, I have attempted to contact the victim on this ahead of this in case there was a bond motion. I haven't successfully. Nothing further from the people other than.
just so that we're,
He's currently on probation. That's why he didn't get a PR bond. Is that correct?
Yes, Your Honor.
Nobody mentioned that to me today.
I did not know that.
Bond will remain at 3,010%. See you next week for your exam, okay?
Okay.
Thank you.
Thank you, Your Honor. Okay.
Mr. Holland, you're all set. You should let them know that you're ready to go.
I was just in busy, I wasn't trying to be disrespectful by putting my head down.
Yeah, you need to let the deputy know that you're free to go. And your bond has been reinstated. Continue for Washington. Yeah. Collie is still in the room. Where Mr. Feigelson go?
My guys are still about to be giving them a bond.
Mr. Feigelson, are you all set in the room with Mr. McCauley?
I am, Your Honor.
He's not returned.
Yeah, I'm not sure. Let's leave it on for an exam, Your Honor.
Continue to exam.
Yes, Your Honor. Thank you.
What are you all set?
I have one with Mr. McCollum, it should be one shortly, but I think.
Yeah, probably because these other two were tying up the room. I
Yes,
just,
I'm being pulled in Judge Flores, so I'll be back over.
no problem.
As soon as I can.
Mr. Knox, you can let them know you're all set.
All right, thank you.
You're welcome.
On this side of the attorney's being.
There you go. Police call transfers.
Good morning, what's your name?
My name is Zachary Smith.
What court you looking for? What judge do you need to see?
I think the 55th.
Yeah, this is not 55th. You should let the
Yeah.
deputy know.
There you go, ma'am.
Which court is he looking for?
Supposed to see the public defender, man.
Which
I'm not
court is he
supposed to
looking
like
for?
I'm not sure the court is a public defender he's supposed to meet with right now.
Oh, okay, well, he's in the wrong room, then he's in 54A District Court. We're waiting for Mr. McCullum. We're supposed to have Quandell McCullum at 8:30.
Oh, I think that's supposed to, ma'am. Gianna, let me check real quick, okay?
Thank you.
No, it's actually +3.
Hey, you got my code? So we'll pull you out, okay? I didn't know you know, that's crazy. Yeah. Hey, Your Honor,
Yes, sir. Can you hear me?
we bring McComb here in about 3 minutes.
Thank you.
Yeah. Your Honor.
Yes.
Here you go, he was moved to the post, so he here now.
Okay, very good. Mr. McCullum, can you hear us?
Yes, ma'am.
Okay, you can have a seat. We're waiting for your attorney to return to the courtroom.
Okay.
I'm gonna go.
Thank you.
You call yourself.
Mr. McCauley, can you hear us? I'm not you, Mr. McCullum. There's somebody else who's I'm calling, similar last name though. Mr. McCauley, can you hear me? Mr. Michelson, are you ready?
Yes, Your Honor.
On the record, in the matters of the people of the state of Michigan versus Quandell McCullum, file numbers 23-03167 and 24-02346. Council Pence, please.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. McCollum. I believe he's present by way of video conferencing from the Ingham County Jail, Your Honor.
So let's see if I brought him back. Actually, let's do that.
What do you know?
He's got to return from the breakout. Okay, there he goes. Mr. McCollum, can you hear us? Okay, today's the date that was scheduled for probable cause conference on at least one of the files. I think the other one might be scheduled for PCC. The handwriting looks like it's for tomorrow. And then the exam is scheduled for the 29th on 23-03167 and for the 30th on 24-02346. It's the handwriting.
The people are ready to handle both the PCCs today.
Okay.
As is the defense, Your Honor, if the court's okay with that.
Okay, let's see. How are we proceeding on these?
Your Honor, we're going to be leaving these for exam. There is no offer at this time. The people will be requesting an adjournment in the examination date due to the defendant's creation of new evidence and calls to the victim from jail that need to be investigated by a detective. Now, it looks like we already have one assigned, Detective Stephanie Kennedy, but it will take, usually takes at least 2 weeks for that to happen. And assuming the court grants that adjournment request and sets new dates, I'd ask that these two cases be set for the same date because they contain overlapping witnesses to handle at that point. Ready to hear about those contacts, happy to get into it. I'll also be asking that we set it for a P53 hearing in each file and for his phone privileges to be completely revoked today. And his bond to be revoked. Okay, I have been on this case since about 11 a.m. yesterday. In that time, I immediately discovered by running the victim's phone number that he had called her 187 times from jail. He'd only been in for 7 days at that point. So he called her 187 times. I then contacted the jail to let them know he's talking to her in violation of this court's orders, and he's tried to do so 187 times, not including the e-messages that he sent her. And the jail blocked him from being able to call that number. My office then had lunch, case review, and came back at about 2:30. 3.5 hours had passed. In those 3.5 hours, that number then jumped up to 201 times as he started using other inmate accounts to call her. And then he was instructing her to get a new phone number with a new account and to not put her name on it because that was a mistake she made the first time. She wasn't supposed to put her name on it, which she did. And so then she gave him a phone number that apparently doesn't have minutes on it at the moment, but he tried calling that number 16 more times after that. So we're at 227 calls. That is not including the several calls that he made to his family and then had his family three-way her in order to talk to her through the family's phone numbers. So we're at roughly 230 calls in about a week after the jail already told him, don't do this, you're being caught. He then took steps to evade detection by using other inmate accounts and getting other phone numbers. And while I have not had the chance to review all of these calls because I've been on this since 11 o'clock yesterday, from the ones I have been able to listen to, he has told her, don't come to court, you got what you want. Just let this go and I'll leave you alone. So there is likely going to be felony witness interference charges added in each file, which because of his tab 4 status will be discretionary consecutive life offenses in each of these files. So as a result of that, I'm asking that all of his jail privileges be revoked with a carve out that he's able to speak with his attorney, because I'd very much like for him to be able to talk to his attorney and his attorney to remind him that all of this is very bad ideas for him to do. But it needs to be a full blackout from him being able to talk to anybody, because he has been using his family to talk to the victim and to commit felonies. technically his family members, the ones who are on that phone call, are either accomplices or accessories. I'll know more once I look through more of these calls. But I don't think anything else is appropriate. I think his bond needs to be revoked, P53 hearings held, and his privileges fully revoked pending the new PD date. And that's in each file.
Mr. Feigelson, you can respond.
Yeah, thank you. A couple of things, Your Honor. With regards to the request of adjournment, I'll leave that to the court. We are on board with making everything on one date. I think that's appropriate. With regards to the jail calls, Your Honor, I was made aware of those at about 4:30 last night. I made a request to them if they could provide me what they had listened to so I can listen to the calls, knowing that it was going to be brought up today. I've yet to receive the calls or know exactly what was said. At this point, they're allegations. The court hasn't heard them either. So I don't even know if there's enough today to say right now anything more than they're claiming there were jail calls. I haven't heard them. I haven't seen the catalog to say he's calling her, Your Honor. So I would ask that we set this out and have them provide me the proof today of the jail calls they have listened to that they're relying on today. At least represented to the court, they've listened to it yet. I haven't been able a chance to get them or hear them, Your Honor. Thank you.
Okay, taking first the request to adjourn, which is due to the voluminous allegations of phone calls, over 230 approximately at this point, and the need to have a investigator assigned on this case. Based on the allegations and the information provided to the court, I'm going to find good cause to adjourn the exam in both of these to a date and time so that we can hold both the hearing for the exam and the bond violations that have just been alleged at the same date and time. So for your information, Mr. McCollum, the allegations that there's been over 230 calls to the alleged victim, those would be bond violations. And those are bond violations on both files that you have before the court, because I see the same thing listed. You have the right to have a contested hearing on those bond violations and to be represented by your attorney. But if you are sustained a violation or violations of your bond conditions, your bonds, which one is 75,000 cash surety, the other being 150,000 cash surety, both can be revoked. You could be remanded in custody with no bond pending the ultimate resolution on each of these files. And then you also have a contempt of court that you would have to address. And contempt of court is punishable each by 93 days in jail and or up to $7,500 in fines for each contempt that's sustained. Do you understand that? If you responded, I can't hear you. Okay, so for the purposes of today, I'll enter a not guilty plea as it relates to the allegations that you have violated your bond conditions by having contact directly and or indirectly with the alleged victim. The court's finding good cause, so I'll reset both of these exams to the same date and time. And then additionally, there's been a motion to address your privileges while in the custody of the jail. That request or motion to revoke his privileges is going to be granted because of the extensive nature and the allegation of the gross disregard of the court's order, which is to not have any contact directly or indirectly or through third party with Tamaris James. And so all jail privileges, including phone calls, video, visits, emails, etc., will be revoked, except you do have the right and privilege to continue to have communication with your attorney, okay?
Yes, Your Honor.
Okay, do you have any questions at this time for the court?
Sir. Okay,
I'm sorry, what? I didn't hear you.
not really, Your Honor. I'm just like mind blown because I can't even talk to and I haven't even talked to anybody, but I have no questions. I'll talk to my attorney about it.
Okay, well, that's easily flushed out because obviously jail calls are recorded and advise you that it's recorded before you even speak. So and your attorney will be able to get that information. And if there's a reason the attorney believes that the information is not you or that this was allegations that were improperly made against you, I'm sure he'll address that immediately once he receives that information. Until then, to both safeguard the alleged victim from any further potential phone calls and to also protect you from any new charges, because I can guarantee you that it's going to happen if you think you're going to continue to make phone calls in violation of the court order. We're going to restrict your privileges, and that way you won't even be tempted to make phone calls or have family members potentially make phone calls on your behalf. So that way we won't have any more allegations of witness interference. Okay, sir? Any additional matters for today's record? I'm going to get you your next date.
That was my next question, Judge. Thank you. No questions.
October 17th. Is October 17th at 9:30 work for you?
Judge, is that a Thursday?
Yes.
I'll make that work.
That works for you as well, Mr. Pfeiffer.
Yes, Your Honor. I may or may not be in trial, but if I am, someone else will cover it for me. I'm not gonna make my schedule hold this up.
Okay, October 17th it is in person at the court. Any additional matters for the record?
No, Your Honor.
No, Your Honor. Thank you.
Thank you, you're all set.
Have a good day, everyone.
Thank you.
Happy rest of your day, Your Honor.
Same to you. Destiny Sykes.
Good morning, Your Honor.
Morning, which matter are you here for?
I am here for Tiley LLC versus Gala Rentals, the subpoena to appear for creditor's exam.
Okay, sounds good. No one has appeared yet. The other party, but we'll see.
Thank you, Your Honor. Your Honor, if I may, I have a very likely suspicion that the defendant is not going to appear. It appears as though someone named Pastor Wendy filed something in this matter about service. I don't know if you have a copy of that.
Okay, I do see a letter in the file from a church indicating that the papers were left on at their building.
Yeah, Your Honor, I wanted to address that because so at this address, there are multiple businesses owned or operated by the McDonald's, Mr. Michael McDonald and Miss Heather McDonald. United National Church is one of them. Michael McDonald and Heather McDonald, the owners of Gala Rentals, the defendant, are officers and or directors for the church. But But either way, they're all located at this address. The church has the same resident agent, Mr. Michael McDonald, as Gala Rentals does. The Mr. Ramsey, our process server, in his affidavit, acknowledged that he put it on the residence, so the residential building located at this address, not one of the business buildings. At this address, I believe there's a winery, there's a hall, like an event hall, there's Gala Rentals, and there's a church. They kind of have an all-inclusive service of businesses at this address. So it is plaintiff's belief that United National Church, Pastor Wendy, who again is a director with Heather and Michael McDonald, is simply just trying to avoid complying with the court's order to appear today. So if Heather or Michael, I guess Heather is the officer of Gala Rentals, the only officer. She's president, treasury, secretary, and director, but Michael is the resident agent. Plaintiff would request the court issue a bench warrant for Heather, the officer of Gala Rentals, because it seems like they're going to try anything to not appear for this creditor's exam, Your Honor.
That's unfortunate that Pastor Wendy would send a letter to the court under those circumstances. We'll give her 2 more minutes, give them the benefit of the doubt.
Thank you, Your Honor.
No problem.
Yeah. Yeah, I didn't want to. Oh,
You guys waiting for somebody else?
Nope, we're all set. Thank you. You can submit a bench warrant.
For Miss Heather McDonald, Your Honor?
That's correct.
Great, thank you, Your Honor.
No problem. What is the amount due?
Let me pull that up. The amount due is $29,453.19.
You can do a bond of 10%.
Okay, will do, Your Honor. Thank you.
Thank you. Ms. Below? Okay, on the record in the matter of LVNV Funding LLC versus Edward Cade. This is file number 24-00760. Have your appearance, counsel.
Janice Blau on behalf of the defendant Edward Cade.
I see Attorney Katz here.
Yes, Your Honor.
Okay, let's see. I just called the case. Can you put your appearance on the record, please?
Good morning, Your Honor. Andrew Cates, P78292 for LVMV funding.
Okay, today was the date that was set for a motion for summary disposition. Have you all had any conversation about this matter privately?
Not today, Your Honor.
Okay,
Excuse me, but we did have some conversation. We did not, but I had conversations with the firm, and you should have, Mr. Katz, a stipulated order of dismissal prepared by your firm. I have it in front of me, and I emailed my permission to approve the order, and you should have it in hand.
Checking again.
I'll put you both in a private meeting room.
Thank you.
So what is
Come on.
Okay, council, did you all come to a resolution of this issue?
I believe we have it resolved, Your Honor. Mr. Katz should be back shortly.
Yes, we do have a resolution, Your Honor. The councils have agreed to a conditional dismissal in this matter. I have obtained permission to sign for the defense counsel on the conditional dismissal, and we'll be submitting that to the court today.
Okay, very good. Any additional matters for today's record?
No, Your Honor, thank you.
I have nothing further, Your Honor. Thank you very much.